Section 3, together with Article 259 of the Constitution, which talks to how this Constitution should be interpreted, and more particularly when it says in a manner that promotes the values, the purposes, and principles of this Constitution, and contributes to good governance. So I urge this court, with all the humility, that although this is a petition basically under Article 140, as defenders and protectors of this Constitution, you, with respect, cannot allow what has happened at IBC to go without some kind of action in the lines that was suggested by my learned senior, Firoz Norji. Impunity must be punished. Impunity must be punished. And impunity unpunished breeds arrogance. And arrogance leads to arbitrary exercise of power. And without that being done, this commission, which has got the protection of the Constitution, without the court making some interventions, it still be a divided commission with a triumvirate that runs the affairs of a commission that is supposed to protect and defend the sovereignty of the people. And what I'm saying in a nutshell, that this election cannot pass on account of violation of the Constitution, even by the constitutional dictates how this commission should run its affairs. If they cannot conduct their affairs in the manner dictated by the Constitution, then how can they preside over an election, and that election have some legitimacy to the people of Kenya and to the world? Secondly, and this would be my last point, that if you look at Article 138, sub-Article 4, and my learned friend Mr. Otiende address you on this, that requirement for a successful candidate getting 50% plus one of the votes cast is not an idle provision in the Constitution. It requires of the Commission to come with it before your Lordship seriously when there is contestation, and put the numbers before you in rebuttal to the case that we have put before you. My lord friend, Mr. Mahat, who is also my very good friend, in his address, he was not talking about what the law requires or what the Constitution requires. He was saying, this is what we do. This is what the KISII do. There was no constitutional or legal foundation that he was resting his arguments. And therefore, yeah, my lady and my ladies and your lordships, I would ask the court to apply the provisions of the Constitution to the letter holistically and allow this petition and return this country and back to the people who are sovereign and let a proper choice be made of the person who is going to lead Kenya in the next 5 years.
Deputy Chief Justice, Your Ladyship, and my Lords of the Supreme Court. Was very simple, by the second petitioner, I think we are the second petitioner as amended, was very limited to a legal issue. It was, what was the position vis-a-vis the election and the role of the commissioners? Now, yesterday, and I think Justice Lenola said something about tweeting and stigmatizing, but in a nice way. When this petitioner came, and I had said it in my opening address, and yesterday Mr. Ngatia said, senior counsel said something very, very, I mean, it's our country. He said, this is one country that even the humble can go to the top. But there was a caveat that seems to have been missed out. If you are a normal, humble person who comes to challenge a presidential election as required by the law, you still get targeted as being a surrogate, because that was repeated 3 times. So there seems to be caveats in these things that we don't seem to know about. Yesterday, my lady, Justice Njoki, asked a very direct question. What is the role of these 6 commissioners and the chairman? Because we seem to be getting in a very empirical chairman. This morning, we got absolutely no idea, except the court was taken to Section 11A and B of the IEBC Act. We were told nothing more. From what I can now see is that these 6 commissioners are supposed to be flower girls and page boys at a wedding, with the chairman being the bride or the bridegroom, as the case may be. That surely was not the intention of the Constitution. It appears that that's because I was actually waiting for that answer just as much as your lordship and lordships and ladyship there was nothing given. Please go to 11A. That's all you were told. We have an umpire, and I'll use it in the cricket term because in football it's called referee. But here in the cricketing terms, it's called an umpire. It is supposed to be an independent umpire. But I heard some I was a bit surprised yesterday when I heard words like shock and awe tactics. And surprisingly, the shock and awe tactics actually came out in one of the protagonists, the ones, the protagonists of we've won, and that was in one of the affidavits. And these are the direct words that an umpire is using. So how is this umpire as independent as they are claiming to be? That is my client's case, that we need an independent body. The second one, we were told by the umpire, get over it, quote, unquote. We were told by one of the protagonists, move on. If there has been a breach of a constitutional, and as it has been our submission, Article 138, 3C, if there is a breach, do we just move on? That's what we are being told. Forget the transgressions that anybody is doing. Justice Lenola, in the opening day after the petitioners had made some submissions, asked a question which I didn't see anybody answering. He asked a question regarding Regulation 87.3, where he had stated that if it should be struck down, but it's already been done. So, that was the regulation which was in place. If your lordships and your ladyships will look at my submissions, my original submissions we had filed, and we specifically addressed that issue. What is a nullity is a nullity, and I believe it is in the McFoy case, it's an English authority, that we have quoted in our original submissions. So I hope, Justice Lenola, it answers your question.
Thank you.
because I think nobody here actually took those questions seriously. They didn't answer them. And I don't mean to be disrespectful or being facetious at all. As far as from what I can see is that this, by the law, by Article 138(3)(c), it says commission. We were told commission, but it doesn't say commissioners. That was a distinction being made yesterday. It says commissioners, doesn't say commissioners, but commission. With due respect, all those commissioners are appointed, well, not at the same time, but go through the same rigorous process. Does it mean all animals are equal, but some are more equal than others, which means the chairman is more equal than anybody else? These, like I've said, and I repeat again, are just flower girls and page boys. That surely cannot be the intention, could not have been the intention of people who drafted this constitution. We go back to where we started from, and I've said that in my original submissions. Where did we come from? We need to know where we came from. One-man show? Surely that cannot be the issue. The other issue that the Chief Justice asked yesterday, why was it not declared to everybody? And that's where my client, that there were all these problems, these commissioners had walked out, the transparency, accuracy. Nobody has given us an answer as we sat through this today. You specifically asked, Madam Chief Justice, why was it not declared that there were these problems, 27 constituencies? Nothing. We couldn't do it because there was a problem. I don't want to go into Maina KISII case, but you were quoted paragraph 287 of the Supreme Court, which I called RILA, which was RILA 1 or 2. But please, before just looking at 287, please look at paragraph 292 of this court's decision. I don't want to repeat it, but this court specifically said, it is in my original submissions, we fault the appellant, who was the IEBC, and the chairman, who was the current chairman, for there being no verification by the commission. We've been told we've misread the section because it's polling stations. With due respect, if it was going to be only polling stations, why send it to the National Tallying Center? It is for the public to know there were mistakes here, there were no mistakes, whatever else there was. A question was asked by the court yesterday. Why did the running tallying stop? Nobody's given us an answer. All the difficult questions that we were to get answers for, to which my client, as a voter, and as Wanjiku, I keep on saying, we have not received any answers whatsoever. No affidavits. In fact, the sad part is, despite this whole matter being consolidated, we were considered the surrogates. Nobody sent us any papers to sign. I have two requests from this court, as I have said, and this was what I was thinking of last night before I went to bed. People say it's a very overused word, but in these circumstances it's ideal and can bite when occasion demands. The toothless bulldog is long dead and buried. Please, Madam Chief Justice and honorable judges of this court, bite, and bite for the glory of this court. And in closing, whilst we said, we were told our petition is much ado about nothing, and like I said, we've really been battered, but we shall soldier on. I will use Martin Luther King's words, because I suppose, unlike Professor Guido Muigai and Mr. James Orengo, I went to a school where they didn't teach us Shakespeare, they taught us Things Fall Apart. They went to the posh schools. And all Martin Luther King said in 1968, at the speech given at the National Cathedral, we shall overcome because the arc of the moral universe is long, but it bends to justice. That's all we request. Can we have justice for all of us, for the voters? Because the two parties just think about themselves. They forget us, who are the voters. Thank you. And I donate my 4 minutes back to the court.
Thank you. We will have the third petitioner, Youth Advocacy Africa, and Peter Kireka.
Madam Chief Justice and Madam Deputy Chief Justice, and may it please the members of the court. Yesterday, and for a section of this morning, Your Ladyship, I believe we've been allocated 30 minutes. I see the clock says 15. The directions will clearly say 30 for us. Youth advocacy.
I don't know whether there was any question directed to you.
Yes, there were. But the direction said 30 clearly.
No, the directions I have.
Yes, for youth.
Yes, for youth advocacy is 30 minutes.
30 minutes, yes. I think the clock said 15. Yes. I was a bit concerned, yes. But for yesterday, for most of yesterday and this morning, members of the court.
Sorry, Counsel. Yes. For our record.
Yes.
Introduction.
Yes, Your Lordship. My name is Tom Asharia. I appear together with my colleagues on record for Youth Advocacy Africa and Peter Kireka. Most of yesterday and this morning, you are treated to the theory of an election as it ought to be conducted. My colleague, Julie Soweto, has demonstrated to you what every Kenyan knows. Mambo kwa ground ni different. I call your attention to the affidavit yesterday presented by my good and learned friend, Professor Kindiki, which has been projected. It's the affidavit of Veronica Duarte. She deposed that she is the Secretary General of United Democratic Alliance and was the Deputy Chief Agent for the 9th and 10th respondents. In particular, I call your attention to paragraph 7, where she states that the verification process went through a 3-tier mechanism. At paragraph 7, she says the second tier was at the constituency level where the following actions were undertaken. She then goes to subparagraph C, and that is the one of interest here, and this is what she says. In case of any errors, this is at the constituency level, on Form 34B, the same would be corrected. That is the key. Those are the key words. She then goes on at paragraph 8 and says that the third tier was at the National Tallying Center at Bomas of Kenya, where the following activities took place. We go to paragraph 8F. The verification team would also verify that each of the uploaded Form 34A in the public portal is a replica of the original 34A presented by the constituency returning officer, and in instances of discrepancies, the errors were noted. She then says at G, the team would also verify that the data entered in the IBC online system for purpose of tallying from all original forms was correct. In case the data entered in the IBC online system is incorrect, the same was corrected on the online system. She then goes at J, a verified Form 34B would thereafter be generated at Bomas. Another one, having corrected at constituency, another one now is generated at Bomas and supplied to the candidates' agents. I specify these particular provisions because, members of the Honorable Court, this is precisely what the chairman of IBC was told in the minor KISII case he could not do. And it bears reading because, as has been repeated here severally, and perhaps I shouldn't repeat it too many times, he is qualified to be a Supreme Court judge. And so we know he understood minor KISII. So it is important that we understand what he did not understand about the following passage. It is evident, I'm reading from minor KISII, it is evident to us from the above sequence of events that the role of the chairperson of the appellant is circumscribed. Article 138 deals with events at the polling stations where votes are counted, tallied, verified, and declared. The appellant, that's the commission, as opposed to its chairperson, upon receipt of prescribed forms containing tabulated results for election of president, electronically transmitted to it from near 40,000 polling stations, is required to tally and verify the results at the National Tallying Center without, this is the key word, without interfering with the figures and details of the outcome of the vote as received from the County Tallying Center. Minor KI states further, the chairperson, on the other hand, is appointed under Article 250 of the Constitution. The chairperson cannot be and is not the commission. It goes on to say, and I say this because my good friend George Morogo this morning told you that whether the chairman is the commission or the chairman is a matter of context. It is not a matter of context. Minor KI put that debate to rest once and for all. And finally, to suggest that there is some law that empowers the chairperson of the appellant as an individual to alone correct, then that's the word, correct, vary, confirm, alter, modify, or adjust the results electronically transmitted to the National Tallying Center from the constituency tallying centers is to donate an illegitimate power. Such a suggestion would introduce opaqueness. These were the words used by the 4 commissioners who disagreed with what was going on at Bomas. Opaqueness and arbitrariness to the electoral process, the very mischief the Constitution seeks to remedy. I don't know how much clearer it can get that what the chairman of the commission did was the very opposite of what the Constitution required him to do. Now, Minor KI was itself based on several decisions of this court. The first of those being Wanjohi, which is a 2014 case, and it is cited there, where the court said, apart from the priority, this court said, apart from the priority attaching to the political and constitutional scheme for the election of representatives of governance agencies, the weight of the people's franchise interest is far too substantial to permit one official or a couple of them, including the returning officer, unilaterally to undo the voter's verdict without having the matter resolved according to law by the judicial organ of state. The only organ under our constitutional framework permitted to correct at any level, let alone any of the 3 levels that the chairman of the commission undertook, is this court. It is manifest to this court that an error regarding the elector's final choice, if indeed there is one, raises vital issues of justice such as can only be resolved before the courts of law. We reiterate as we conclude that there is no doubt from the architecture of the laws we have considered that the people of Kenya did not intend to vest or concentrate such sweeping and boundless powers in one, that the system was accessed thousands of times by officers at the Bomas. And so clearly, you had returning officers, specific special returning officers, assigned to changing forms on the portal, as has been demonstrated this morning. In our submission, the alterations made to this system, to the forms, these so-called corrections that were done at 3 levels, so alterated and contaminated the outcome of the election that it is now incurably defective and incapable of being rescued. Now, we were challenged to demonstrate from their own forms what the problem was with the forms. Now, time doesn't permit me to take you directly to those affidavits, but the Commission has filed an affidavit through the firm of Iseme Kamau and Maema in our petition, the affidavit of Esther Wanjiku Wanjohi. She attaches 14 forms. That's about a quarter or 30% of the forms that you asked to be taken through the scrutiny. Of those 14 forms, 8, representing 57% of the forms, 8 have irregularities, have gaps, have problems, including the fact that when you read them with a QR code, the serial number that shows up is for a different polling station. The problems are correction problems, tallying problems on those forms submitted by the commissioners themselves, by the commission itself. You have an affidavit submitted again by the commission, the affidavit of Nzika Mwololo. Same problems. He has two forms. 50% of them, which is one form, has an incorrect addition where the rejected votes have been added as part of the total. Now, in light of what my KISII said and what my learned seniors have said here this morning, my mind is taken back to a few months ago when a few of my colleagues here, my good friends here, came before this court and told you and persuaded you that a process known as BBI, one where 1 million signatures had been collected, one which had gone through over 40 county assemblies, one which had gone through both houses of parliament, was irredeemably void and null because the president used the wrong process. And they persuaded you. And I invite you to look at paragraphs 1,500 and 1,500 of your judgment in the BBI case, where you stated that any process, any activity undertaken without constitutional authority, as the chairman of the IBC has done in this particular case, must be declared null and void. And the terms null and void, and this is one of the cases we've stated before you, the case of McFoy versus United Africa Company, is captured in the following words: if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have a court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. That is the fate the Form 36, the Form 34D, issued by the chairman of the commission in this matter, must suffer as well. Now, my learned friend, Mr. Mahat, has taken you through some numbers. And as I've demonstrated, and as was demonstrated earlier here by my colleagues for the first petitioner, when you have a process where the numbers are so adulterated, where the forms are so compromised, what numbers are we talking about running around the yard? It is impossible to get a hold of the number that was used either for the 50+1 or for the tallying or for the verification, which, as you have heard, was changed 3 times. Now, you asked, I think, of the petitioners, how did we get to this place? Like every slow train crash, a train crash in slow motion, those of us who lived through the repressive days that led to the Constitution of 2010 will tell you that it did not happen one day. My good friend Mr. Morogo has told you that the Gazette notice by which the chairman appointed himself as the presidential returning officer. And we need to note, because the defense put here yesterday by the commission, was that he appointed himself on the basis of your judgment in 2017, where in passing, you said that there is a national returning officer. Now this year, he has upgraded. He upgraded himself to presidential returning officer. Now you've been told that Gazette notice means nothing. And I think yesterday you were told we ought to be grateful to him because he had the good grace to publish in the Gazette his unconstitutional appointment. Now, whether you publish misconduct in the Kenya Gazette or you publish an offense does not imbue you with some sort of value or does not imbue that process with some good grace or quality if the Constitution does not permit that office to exist or does not permit him to conduct himself in the way he did. A Gazette notice does not improve it. But perhaps more importantly, If it meant nothing, why publish it in the first place? If it meant nothing, why publish it at all if it meant nothing? But the point I wish to make is this. Complaints were raised. I think I've seen letters written by the party that nominated the first petitioner. There were newspaper articles complaining, gazette notices, newspaper notices complaining that ballots had come without commissioners being told, but you'll get to hear that a bit more. There were complaints made by civil society. But as happened with Kenya, when we ended up in the position we ended up before the 2010 constitution, we keep pushing these things away to the back of our mind. And people go to campaign, the rest of us go on with our lives, and he publishes a new gazette. I am now the presidential returning officer. He goes on ahead and does other things, allocates duties. You go look after flowers, you go be an usher. These are slowly and then progressively, we end up with what was this morning called an imperial chairman of the commission. And so this is how we ended up at this unhappy day, where 4 commissioners say that we cannot stand by these reasons because we were not involved in everything that was done with them. But apart from that, and apart from those obvious misdemeanors and indiscretion have been pointed out here this morning and the day before yesterday, in our petition, we've raised the fact that even other statutory requirements, the KPMG audit report, for example, was only published on the 5th of August, 4 days to the election. And parties kept asking for this report. Where is the report? And we'd all be told, again, in that most Kenyan fashion, tunashughulikia hiyo maneno. So you go back and campaign, go do your things, and you wait. And on the 3 days before the election, it is dumped on the website, and no one is actually told. There was no press release saying, we've released KPMG now. We had to find it there by accident. Now, when you finally go and look at that report, and you'll see a copy of it in the particular pages I refer you to, pages 1153 and 1155 of the petition, you will find that KPMG complains that both the Commission and Smartmatic withheld critical information as regards how the voters register was being accessed, and that by the time the report was written and released, they had not received that information. That was the KPMG report. Now, again, the Commission comes here this morning and tries to explain to you how they arrived at the question of voters identified with the printed register. One of the things you will not find in the affidavits filed by the Commission is an account of how many Form 32As were signed as required by law. And that is the only mechanism that the regulations identify for identifying those who have voted outside the KISII system itself. And so what they've done, and that's what I think one of the honorable judges yesterday called a bit of a lecture here yesterday, is do reverse mathematics. You begin by adding up all the votes you say were in the Form 34C, and then you subtract from that those who were identified using the KISII. You have not been given a report of how many Form 32As were signed. In addition to that is the tortured question of Regulation 69, Sub-Regulation 1A. And I've not had anything said about that here. Now, Regulation 69, 1A of the Election General Regulations requires that every time a voter is identified using the KISII, the printed register must be crossed out. And this is not a function of voter identification. This is an audit tool to ensure there is no fraud. A distinction has been made between what was before the Court of Appeal in the case raised before you about the printed register and what the law requires as regards the crossing out. For some reason to that number, for starters, is not an accountable figure. What they've done, and you'll find that, I think, at paragraphs 73, 74, 75, and 76 of the chairman's replying affidavit in our petition, is taken two constituencies, this is Makadara and Kibra, and said that in those two constituencies, we had an average of 2 stray ballots per polling station. They take an average. And the reason for this is that it is not possible to account for stray ballots in Kenya within the time that this court must rule. Because under Regulation 81E, once stray ballots have been identified, they are put in an envelope and neither Form 37B, 38B, or 39B have anywhere to indicate stray ballots. They are indicated in a polling station diary. The only way of arriving at a precise number of stray ballots and identifying to whom they strayed, if I may use that word, polling stations in this country. And that hasn't been done. And so we can't speak with any certainty here when a figure is thrown at this court that there are 96,000 or 92,000 stray ballots. No one knows. The truth is that no one knows. That's number one. The second thing is that in arriving at these mathematics, the chair of the commission says that in six polling stations in Starehe and Mathare, the officer locked up the forms in the ballot box. And he then says that in the 6, we cannot account now for 4,200 ballots. Now 4,200 divided by 6 is 700. What he's saying is that in those 6 polling stations, there was a 100% turnout. You will see that at paragraph 74, 75, 76 of his replying affidavit. Now, when you go to the forms on the portal, as we've been asked to do, the turnout is not 100%. And so that is a false affirmation in his affidavit. I think much has been said about the forms and the PDFs. I think I won't venture to say anything about that. I think I should also state, because it was part of our petition, that by the time we went to the election, and I think as of today, an audit report as required by the elections technology regulations has not been provided or done. It's not on their website, it's not been provided. The elections technology regulations under the Elections Act require an annual audit under Regulation 10 and 11. You will find in a response by the chairman to the first petitioner's party a letter where he says we could not do the audit because we did not have money. He has now annexed, in response to our petition, a certificate, a 2-page certificate, where they say we have 10 reports, but he doesn't attach those 10 reports. They are not on the website, and we have not been provided with them as of today. The purpose of that audit is that it might become impossible or unnecessary for us to spend time here discussing things called logs. And the only logs my grandmother knows are those she uses to warm herself. And yet she's the voter. Constitutional Court, which states that unless the public is able to, independent of an expert, audit the process used to conduct an election, then that election is not verifiable. That decision is before you with our digest of authorities. And it speaks to something a bit more nefarious, if I may use that word. We have just been told here today that we had foreigners who have accessed our IT systems. I can't pronounce their names on account of my county of origin. Now, and what has happened, submission I would make, is that the IEBC ceded control of the process of determining the sovereign will of the people of Kenya to a foreign entity that now says that that data is the intellectual property. And there are very, very serious questions that arise. And I say this because they were asked of the chairman of the commission. For example, this data, they now say is theirs. Has it complied with the Data Protection Act? Was this company subjected to the provision of Section 31 of the Data Protection Act. And what are the consequences of surrendering our data, our biometric data, to foreigners who now tell us that is now their intellectual property? And I think Kenyans would be forgiven for saying that we're going soon to have leaders made in Venezuela, not in Kenya, not by Kenyans. Allow me to use the few minutes left to address some of the questions I think you raised, especially as regards remedies. But before that, let me just point out that amongst the other failures by this commission was to provide the Parliament of Kenya with amended regulations, which they promised to do last year, but presented amended regulations in June or July as Parliament was going on recess Sendai. And so again, they'll come and tell you the law was not amended for us to rectify some of these things, but they submitted their proposals late again and outside the election operations plan that they had said they would do. Now, printing of ballot papers, a specific question was asked of them. This company that you have procured, rightfully or wrongly, is accused of having led to the postponement of an election in Nigeria. And the chairman again said, there's no problem, tunashughulikia hiyo maneno. On the 8th, we have the largest postponement of elections in the history of Kenya. The elections postponed on 8th August was the largest number of postponements in the history of Kenya. So what should we do? Kenyans who run into problems and who find complicated issues they don't know what to do with, I always want to say, do something. Can somebody do something? Somebody should do something. That is what we say. But this honorable court has the power to do something. And it has power to do something even in the face of an imperial commissioner, chairman of the commission, who quite casually says, Mtadu, do something. You have power under Article 140, and again, in my view, I think the question was asked here about the utility of Section 80, subsection 4 of the Elections Act. Now, I think given the time limitations that this court has to do a recount and a retally properly, that section is one that is not very helpful or useful. The requirement of the Constitution under Article 140, subarticle 3, is for a nullification of an election that is found not to have been in compliance with the Constitution. That is number one. Number two, I think the judge asked of us, what is to happen if we are to then find that this chair violated the Constitution or committed crimes? Again, that is a question that has risen here before. I think in 2017, we have an Election Offences Act. We have Article 251, which make provision for what is to happen to errant and imperial officers, public officers, such as the one whose case is before the court today. And so I think it would be premature to start anticipating what were to happen, because I think our Constitution has sufficient, and I think we must trust it. We must trust our Constitution and the mechanisms it has created under Article 140 and other articles for what is to happen in that eventuality. Madam Chief Justice, Deputy Chief Justice, I want to thank you for the privilege of your attention. And unless there are any questions left for me, I will donate my 1 minute back to the court. Thank you very much.
Thank you. 15 minutes given to the fourth petitioner, Khalifa.
My Lady Chief Justice and the court, may I plead with the court once again that what we are listening to is not a reply. It is a rehash of the case afresh, and it is leaving us in a very vulnerable position because new issues are being raised, and we have had, or may not have, unless you assure us, my lady, that we will have an opportunity to reply.
I think we have already questioned Council to reply on points of law, and you can see all of us are busy. We know what are points of law in our reply, and we know what we ignore.
Madam Chief Justice, only 2 seconds. You said that earlier. We all thought we had. Despite that, Mr. Mashari has taken 30 minutes to argue factual issues, going to affidavits, nothing on a point of law that he responded to. In my submission, therefore, the court will be perfectly entitled to disregard every word he uttered.
Yes, we know how to separate the...
Before I start my submission, so that my time doesn't run, I find myself in the position, I'm Willis Otieno for the 4th petitioner, in the unfortunate position that I'm one of the most mistreated petitioners in these proceedings by the first and second respondents. They served me late, as I indicated already in the pre-conference, and we lost the opportunity to respond. And this court did indicate that when we'll be doing our response, we can comment on some of those issues. We never filed a rejoinder to them because we were the ones who were served late outside the timelines provided by the court. So, but I don't intend to go deep into facts, but I may make one sentence references just to meet what had been allowed before, if that is in order. Number one, my lords and my ladies, we must assert that the KPMG report, the only expert report that has been done on the biometric voter register, that evidence has not been challenged by any other expert evidence. And that evidence which we annexed and referred to, we can now safely conclude that the 481,711 deduplicates that are in that report, 481,711 is admitted. The second point that I wish to respond relates to the question my learned senior Professor Gidu Muigai said, that if these elections are badly conducted, not in accordance with the law, what about the other 5-tier elections where we have governors and senators? One answer, jurisdiction. Every court will have its day, every court will consider the facts of those cases. The third point that I wish to respond to relates to what was asked of when the regulations that gave the chairman the power to be a returning officer were passed, they were law at the time he acted. Simple answer, Maina KISII case had already answered that question of what the law was. Maina KISII case had interpreted Article 138(3)(c) of the Constitution. That was the law, and any regulation being made to circumvent that law by itself is unconstitutional. As I said, Helef was a petitioner in Maina KISII case. Helef came to court. Helef has come back to court to enjoy the fruits of his litigation in Maina KISII case, and I was his proud lawyer in that particular case as well. My lords and my ladies, reference was made that the IEBC saw the ballot boxes for the first time that necessitated the postponement of the elections on the 8th of August. My lords and my ladies, Lycos never disappoints. You've just been told how Lycos, wherever they printed ballots, they've always ended up on the people of Kenya through fake elections. My learned friend, Mr. Gumbo, spoke on technology, and he gave us the Kriegler report. Kriegler report did not say deploy weak and vulnerable technology. Kriegler report required you to deploy sufficient, efficient, integral technology that protects the will of the voter. Kriegler report did not make a recommendation for Jose Camargo, Diego Maradona midfielder, to sit in the middle and start distributing results, as was demonstrated today in the morning. Kriegler report is not an answer or does not excuse a technology to be vulnerable, has 14 unauthorized users called Embakasi South clerks. The fourth point I want to raise is IEBC has confirmed that we look at the portal to tally the results. It is not the public portal that is used to tally. Tallying is a function of the commission. The commissioners must perform a tally of those results. And what is the commission vis-a-vis the secretariat? I refer this court to the case of Engineer Michael Kamau versus EACC, where the court specifically said the core functions of a commission cannot be performed by the secretariat. That was the Court of Appeal decision. It's part of the bundle of documents that we've annexed. You are told, my lords and my ladies, when in relation to the question of how integral the technology was, and my learned that Justice Lenaola did ask, when you take a JPEG and it comes out as a PDF, and I tie it to the response, what Kamago was doing in the system, and my learned friend Samane said, he's a plumber. He's like a plumber maintaining the system. Let me say this. Once a plumber has fixed your bathroom, that plumber has no business being in your bathroom when you are showering. If you find him at that time, you tell him, get behind me, Satan, as was said in the book of Mark 8:33 in the Bible, when the devil entered Peter. And Jesus told him, get behind me, Satan. A plumber who is in your bathroom when you are showering after fixing your shower is no longer a plumber, is a sexual offender and should be reported.
Let's stick to the...
I'm guided. Mr. Somane took you through several forms, explanations, trying to explain what is voter turnout. The KISII kit. At the end of the day, when you leave, are you able to answer the constitutional threshold, the question, are those results, is that system of technology simple, verifiable, and accurate? Why the many explanations? Why the kizungu mingi? It should be simple, accurate, and verifiable. What we've been shown is not simple, is not accurate. This court is still left with so many questions as to the true KISII kit logins, as to the true and exact turnout of voters as at 5 p.m. on the 9th of August. You are told that parties must have their own agents to present things here. My petitioner is not a political party. He is not a candidate, but is a voter entitled to participate in elections and to present a petition. The obligation, legally speaking, is on IEBs to provide a free, fair, and verifiable election. There is no obligation on a voter like Hele Khalifa to hire and recruit agents all over the country to watch how the elections are conducted. If you do so, then you will forever relegate the participation of the people of Kenya in a free and fair election to the ability to hire and deploy over 46,000 agents in all the polling stations to watch over their vote and the votes of others. The question was asked, the question was raised by Mr. Ngatia, that election officials are tired, they need to go back to work. Convenience again. I say this. Our constitutional values and provisions should not be sacrificed at the altar of convenience. If the election officials are tired and cannot do another election, please, we have more Kenyans who are willing to do this work properly. Give them that opportunity. And that ties to the point that was said, that Kenyans cannot be in elections in perpetuity. Kenyans must get it right. And I say this with due respect to this honorable court, that the Supreme Court has a higher obligation when it comes to this issue, to ensure that we get what we call regime legitimacy. In countries like DRC,